All right, time to bring in a think tank. I get a think tank when I sub for Vinny. This is so exciting for me. Criminal defense investigator Charles Middlestead, Shania King, criminal defense attorney, and the Bix, Michael Bixon, criminal defense attorney. Thank you guys for being here. So this case, we just got a jury. So this is the breaking news in the last hour. A jury has been selected. 6 women, 8 men, representative of the community. The community is mostly Caucasian, but these folks are mostly older. And as you all know, the defendant, as well as the victim, very young, arguably progressive. What do we think about this jury so far? Who wants to start? Charles.
Well, I mean, if in fact they are of a different generation, I mean, we're dealing with this is a unique case no matter what jury you have, right? You're dealing with gender identity issues, you're dealing with multiple lovers, you're dealing with this. I mean, this is a convoluted case. It's one of the more interesting fact patterns that I've seen in a long time. So I think this would be a difficult case for any jury to sort of wrap their mind around some of these, some of these circumstances.
But Shania, isn't this most difficult because you do have jurors that are older and they perhaps may be more judgmental of a younger, hipper, sexually progressive lifestyle?
I think so. When the jurors are not sleeping and they're actually taking notes, I think they might take issue.
There is no way anyone's sleeping during this.
I think jurors have a tendency to sleep through some things, but this case is juicy. I'll tell you that.
Yeah, Bix, do you think that people can sleep through cannibalism, hedonism, BDSM? I mean, I am wide awake now.
This is as raunchy as it gets. I think that they're going to have a really hard time, though, explaining some of this. You know, especially the sexual assault defense aspect of it to some of maybe these older jurors. And, you know, the nature of this relationship, as Charles said earlier, it's so convoluted and messy. And trying to sort through all this, especially through the different stories that we've heard, makes it really difficult, I think, especially for the defense going forward.
Well, okay, I want to just start off with, we've heard repeated reports about Ezra McCandless being gender identity confused, okay? Now, we are now going forward calling her she and her because that is what we've been authorized to do and that is what she is preferring. So that's what we're doing. But there are witnesses that may say that she's transgender. And this was an issue in jury selection where they asked jurors, are you going to be able to be fair and impartial, hearing that she could be transgender? Why are they asking jurors about transgender if she's saying that she's a she? Like, why is this such a big issue?
I'm guessing it has to do something with what happened earlier in the case that might come out during the trial and how it might affect their decision making. I mean, as it is, no issue, but maybe prior to that, that might play a role in how they decide this case. And I think it's important to get out if it's in any way going to affect their decision making.
Now, Charles, as a defense investigator, are there times where you have cases where you have to almost gather information to prepare your lawyers to be able to pick juries?
Certainly, and sometimes we're actually, assisting in the selection process, backgrounding them. If you're dealing with a small jury pool in a rural area, in a rural county, where you have the ability to actually look into backgrounds, look at their political leanings, look at their socioeconomic status, etc., whether they know each other, whether they're actually living in proximity to the crime scene, in proximity to one another, whether they have worked together, whether they maybe worship together, whatever the case may be. But trying to get as much insight into the jury pool as you possibly can. And this is one of these issues that is so unique and sort of narrowly focused that it's sort of hard to determine how that plays out. I mean, if there's ever been a time, it's now, right? When it comes to the whole LGBT issue, gender identity. I mean, where people are expanding their minds more so today than they certainly were 20 years ago or 50 years ago. So there must be something in the fact pattern in this case that would cause them to ask that question, right?
Right. So, Shania, would you, because that you were concerned, so you're representing this young lady, you're concerned that these issues are going to come out, you don't know if someone's going to say she's transgender, or someone's going to say she's gay, or something else, or she prefers to identify as a man, whatever these issues. When you're picking a jury, are you going to ask about everything?
I'm going to ask about everything that's relevant because, again, we don't want the jury to decide anything based off of their hidden biases. If they have a certain religious belief, we don't want them to decide off of that. We want them to decide off the facts of the case and not what they believe personally, but what they've heard during the case.
Are you concerned, as you sit here right now, for this young lady getting a fair trial? With this, again, with these jurors skewing older, I don't think, I mean, the victim's Caucasian, the defendant's Caucasian, the community's Caucasian. I don't have a race issue with this jury. But the age thing I'm concerned about.
I think that to get the jury to where they need them to be, you need maybe a paternalistic approach where maybe that could be my son, maybe that could be my daughter. Get that to them, get that to that playing field, because otherwise they're going to lean more conservative. They may not be able to relate to the defendant and understand what they're going through unless they too are have family members who are transgender, who have been through a place in their life where they are identifying as a different gender.
I mean, I understand this community is rural. Everyone keeps telling us that, but there's got to be progressive people here because these young people are progressive.
Absolutely. I mean, and again, I think as Shania just mentioned, it's also about relating, even if not to them, but somebody they know.
Sure.
Some aspect of their life. I mean, you have to, even if you go out 10 degrees out, you will know somebody or somehow, have that in your life. And you can talk about that. And I think it's important to bring that up during voir dire, to be able to, bring out these things that can affect your case in one way or another and swing it both ways.
One thing I don't know if they brought up during voir dire or voir dire, it depends on who you're asking, but they brought up the question of PTSD. So perhaps she is going to argue that she suffered from some type of post-traumatic stress disorder, either before the crime occurred or during the crime or after the crime occurred, and why she didn't report it right away. So maybe that's coming out. So, and I think it's good, right? I mean, you guys agreed to preview the jury on what your issues are. Okay, one issue which I don't believe they asked the jury about, and that is, and I think this is really bad for someone who's claiming self-defense and or rape, is that she has filed previous claims of sexual assault. She filed it against her former boyfriend. And this is going to come out. So it has been ruled that the investigation was closed into these claims of sexual assault, but there are report and text messages recovered from her phone, which will serve as evidence against her in this case. Now, Charles, as an investigator, what exactly do you do with this information, and how much do you try to uncover from it?
Well, again, from a defense perspective, you want to master the facts. So you need to know the good, the bad, and the ugly. So if there's going to be anything that's going to come in that's going to bear either in a positive or a negative light on your client, then you certainly don't want to be surprised by it. So that would be a part of our investigation anyway. Even if law enforcement hadn't uncovered it, we would want to know about any previous outcries.
And you'd go talk to this guy, right? We would want to talk to these folks.
Yeah, absolutely. I mean, the last thing we want to do is, in fact, I have a case like that. We were just talking about this today.
Oh, really?
Yeah, where, there are certain things that could come to light that we need to be prepared to deal with. If they do, they probably won't, but they very well could. And so this is a perfect example of something, again, if you're going to be effective, this is part of being effective, is you have to master the facts. You have to know anything out there that may just pop up.
Now, this is coming out. You're defending this young lady. How do you handle this in jury selection?
How do we handle
this issue that she's made a prior claim of sexual assault? The police didn't investigate it.
Well, here, again, I would need an expert, because it's statistically known that women do not always report rape, or they do not report being...
No, she reported it, but the police didn't investigate it. The police shut it down. There was a report and everything. There was So I'm saying that this is coming out. This is going to hurt your client. There's evidence of those assaults coming out. And that young man may even testify in this case because he was a previous boyfriend of hers. Would you say something to the jury, Bix?
Yeah, absolutely. I mean, I think it's important from the beginning how you label her, right? And because, make no mistake, the prosecution is going to label her as a liar, right? Someone who brings forth these claims, who makes wild allegations, and it sort of contributes towards this unpredictable, bizarre, crazy nature of hers that led to this murder. But I think for the defense, it's important to bring her up as a sexual assault survivor, right? And yeah, the police didn't follow through on it, and they didn't investigate it, and they shut down the investigation, but that's not on her. that's on them.
Excellent. I love that. Push it on them. Push it on them. That is brilliant. Okay, so next up, me and the think tank, we're going to continue to dive deep into the killer girlfriend murder trial and talk about how she got arrested, the investigation, and everything else surrounding that.
It happened in thousands of scout troops across America. For decades, countless innocent children were sexually molested by adult scout leaders. The Boy Scouts of America's own secret files reveal that since 1910, they admitted into scouting thousands of child molesters that it knew or should have known were unfit to work with children. We are attorneys representing survivors of scout leader sexual abuse. If you were abused in a scouting program, you are not alone. Come forward and get the help and healing you deserve. Protect tomorrow's children. Identify your abuser and help put a stop to the cover-up. Even if you've been told that you were too late for justice, new laws may allow you a path to significant financial compensation. Call Abused in Scouting for a free, confidential consultation. We have skilled and compassionate people standing by to take your calls.
Call 1-800-803-9492. Again, that's 1-800-803-9492.
Your paycheck. Your family depends on it. But if something happened to you, you need life insurance. And chances are SelectQuote can get it for you for under $1 a day.
SelectQuote found Alec, 38, a $500,000 policy for under $23 a month. SelectQuote found Kenesha, 37, a $750,000 policy for under $23 a month.
SelectQuote's secret? They impartially shop a select group of highly rated companies like these for your best rates. Give your family the security it needs at a price you can afford.
Since 1985, SelectQuote has saved over 1 million families millions of dollars on life insurance. Call now. 800-280-0164 or go to SelectQuote.com. Discover what over 1 million families know. We shop, you save.
This is the kind of card that has America talking. With it, people with Medicare are getting all-in-one coverage for their doctor visits, hospital care, prescription drugs, and more. This kind of insurance, called Medicare Part C, may also cover dental care, eyeglasses, hearing aids, fitness programs, vitamins, even healthy meals and rides to the doctor. With this kind of coverage, you do not need a Medicare supplement insurance plan. You will access your benefits through your Medicare Part C plan for one low and oftentimes $0 monthly plan premium. You deserve to get the most from your Medicare benefits. Call now for free information that may help you get more coverage for less money. There is no obligation to enroll. Whether for yourself or someone you love, call the number on the screen now. Call now.
Attention! The Centers for Medicare and Medicaid Services has officially authorized new benefits that Medicare Advantage plans may include. To get the benefits you deserve, you can call the Medicare Coverage Helpline.
Hi, I'm Joe Namath. If you're on Medicare, this is important information. I called the Medicare Coverage Helpline and they instantly looked up my coverage. In this one simple call, they offered to enroll me in a plan that includes rides to medical appointments, private home aides, doctors and nurses' visits by telephone, and even home-delivered meals. The plan also includes dental, vision, hearing, and prescription drug coverage, all at no additional cost.
Don't delay. Call to see if the new benefits are available in your area.
Call the number on your screen now. It's free.
Call 1-800-497-5903. That's 1-800-497-5903 now.
Welcome back to Closing Arguments. The think tank is still with me. We're going to talk about the investigation now and how McCandless got arrested. It was a little bit convoluted. So this all began on March 22nd, 2018, and that is the day of the murder. But when it comes to the police being notified, it started off with a witness, this guy, Don Sipple. We expect him to testify. He calls dispatch, and he says this young lady shows up. She's got blood around her mouth. Her clothes are torn. She has no shoes on. Her pants are covered in mud. So a cop shows up there. He responds. She didn't have ID. And really interesting, this Deputy Shields, and I can't wait for him to testify because he says she's crying, but no water's coming out. Okay, so what does that say first off?
We hear that in every case.
Do you really?
Yeah, the prosecution's always like, yeah, I never saw any tears. So I've personally just stopped paying attention to that. But, I mean, the defense is clearly going to contend that she was in shock, right?
Right, but now, Shania, you agree that if you have Deputy Shields coming and saying at the time, the day of the crime, she appears to be crying with no water coming out, and you couple that with other testimony from someone else saying she's a liar, she's a manipulator, put all that together, it's harmful.
It is harmful. Maybe she has dry eyes. Maybe she.
Oh God, Shania, could you just pretend to play prosecutor for 5 minutes with me, Shania? Come on.
So if I was the prosecutor, I would say she lied then, she's lying now, and it's all a farce. She purposely came to this house knowing this guy was in the car, and she never said anything about it.
So let me give you some more. We're going to go step by step. So there was blood around her mouth, as I said. She also, I think, on her knuckles, left arm, there was some blood. She was, covered in mud. On her upper right thigh, there was an L-shaped hole. Now, also, Deputy Shields during that visit saw that she had in her arm, the word boy was cut in there. And I think we have a picture of that. We're going to show that. But she had this boy word engraved into her arm. Now, she was transported to the Mayo Clinic, the Mayo Hospital at that point. Again, she's with cops. She's crying. Doesn't say anything about the victim, Alex Woodworth. We have a problem right away, right?
Absolutely not. Not even.
Sorry, excuse
not
me.
Not even the slightest
Why
of
can't
issues.
you just acknowledge? Let
me sum it up like this.
It's a problem that there's a dead guy in her car in the middle of nowhere, and but she didn't say anything. It's a problem.
Let me break it down like this. Not once, but twice now, the police have ignored her cries of being a sexual assault survivor. It's a repeated pattern of the system ignoring her, abuse. And look at her, her clothes are torn up, she's got bite marks, blood all over her, she's cut up. Maybe she'd carve in boy into her arm. But after all she's been through, would you be surprised that might affect your mental stability?
Okay, no, listen, I think she needs to call like 1-800.
It would be a little more helpful if she told Mr. Sipple there, don't call the cops.
Yeah,
that would have said, like, I don't trust law enforcement, they failed me before.
Oh, yeah, no, that's a good point.
That would be helpful, right?
Oh, that is a good point.
But,
and so, and Sipple lives in Dunn County, and she's from Eau Claire County. So for whatever reason, they're trying to get in touch with Woodworth. Deputy Shields, this is a little confusing. Dunn County contacts Eau Claire, excuse me, and this other officer basically says, hey, I saw the defendant, the complaining witness, the victim, and her other boyfriend, Mengel, earlier today. So they're trying to get in touch with Woodworth to no avail, obviously. Now, at this point, deputies, so one person from Eau Claire County, one person from Dunn County, they go to the Mayo Clinic to interview her, and she says, I was attacked in Owen Park, and she says the victim engraved boy in her, and I think at some point she does retract that. Now, this, again, they still have not found him. So for whatever reason, they go back the next day to Sipple's house to re-interview him. They drive there. And this is where I think the investigation got really good. And I believe we have scenes of the crime scene. We do have pictures of that to show the viewers. They're driving there to Sipple's house, and one of the investigators sees a mud-covered road and sees footprints in the mud. And the footprints are not consistent with shoes. There's no details that we would see in shoes, but in fact, barefoot or socks is what they believe. Now, I think that's pretty incredible police work.
I mean, going to Sipple's house is a sort of the first most obvious thing to do, right? Because that's the strongest lead they have because she was there, right? So you're going to start with that. Seeing the marks and the footprints and all that, I think that's good police work for sure. And then with regard to the boy in there, ultimately it's not that she retracts it, she's sort of challenged on it, right? Because they can tell by the orientation of it.
Yes, so I have that. So then actually it's the Mayo Clinic. So she was interviewed at some point in the Mayo Clinic, and that was part of the criminal complaint. At the Mayo Clinic, when she was initially interviewed on the 22nd, the doctor there, he did the exam and he said, quote unquote, her wounds could be self-inflicted because of the orientation. The angle of the wounds in the groin look consistent with self-infliction and those on the right thigh. The wounds on the left arm, the letters were oriented for her to look at. So that's a lot. I mean, that's like, it's not just one set of wounds. It's not just the boy, but now we're talking about the groin area, the right thigh, and the arm. Still don't have a problem, Michael Bixon?
Not even the slightest.
Okay. Have a good night.
No, I mean, think about it like this. I mean, let's take a step back and let's look at it. So she has cutting issues. And maybe she...
I know, this is sad. I mean, this is just, it's so upsetting.
I mean, again, if we're to believe her story, she's a sexual assault survivor twice over. So she has cutting issues.
Why not admit it if you admit everything else?
Of killing him?
No, yeah. I'm just saying, if you're attacked, what's the problem?
Because maybe she doesn't trust the police after having her first investigation shut down. I wouldn't believe them. I wouldn't trust them.
Would you perhaps think that she would call someone else she did trust? She had friends. She had other lovers.
And didn't work out for her too much, did it?
Well, we'll see what Mengel has to say. Shania, at this point, do you find that she did self-inflict not just one, but several wounds? And she did, and to your point, she does admit to hospital staff that she has self-harmed in the past.
I guess a couple of things I would want to know is how recent were the infliction wounds? If they were at one point at the same time, it may show that this was premeditated. If it's over a certain period of time, it shows that she does agree with Bixon, have cutting issues. I think the major problem we're going to have here or the defense is going to have is painting her as the victim when she left out so many details. But again, she was in shock. She's in fear. She has these outcries. I mean, it's a lot going on. I think she's going to have to overcome those hurdles to get a jury to say not guilty.
How early in this case do you start investigating the victim?
Right away. Right away. You have to know, again, the circumstances surrounding that relationship, other relationships that she was involved with, he was involved with, sort of put together the organizational chart in this particular case. I mean, that's what you're really dealing with almost, because there's multiple intimates involved in this case. They all, for the most part, know each other. They're intertwined. And so it's almost like you really need to have like an organizational chart to figure this one out, right? But there's, going back to this last point, I think there's just certain facts that you have to own.
Right.
But you have to have an explanation for them.
Well, yeah.
She has a distrust of law enforcement.
He's right. That's a great explanation.
Yeah, you just have to own them. I mean, and then if you intertwine the gender identity issue in this sort of concept that she has been manipulated by men her entire life. She has all these multiple lovers, and they're talking her into things. She thinks she's in love with one guy. He's gone, yet his best friend sort of talks her into taking a role in that.
No, that's
you know
good,
what I mean?
Charles. Hey, Shania and I, we always blame all the men.
Right.
Blame all the men. Okay, we got to take a break, but Closing Arguments continues at the top of the hour.
I said, did you shoot her? And he said, no. Then how would you kill her? And he said, with a hammer.
Jimmy Rogers faces a potential death penalty if convicted of killing Dr. Teresa Sievers.
Yeah, she's dead on the floor. I mean, it's a murder.
A murder prosecutors say was planned and paid for by her own husband.
This is such a twisted and complicated case.
This is an important message for anyone with Medicare or who expects to join soon.
This card I'm holding in my hand, it's an example of an all-in-one Medicare Advantage membership card.
The kind of Medicare coverage that comes with this simple little card can help you in so many ways.
The Medicare Advantage plan that I've got, it has paved the way for more independence. It's all inclusive. They take care of all my pharmacy, They take care of all my medical. They take care of my doctor bills.
I actually don't even have to pay for a doctor visit, and that's fantastic.
If you're already on Original Medicare or you're about to become eligible, you may be familiar with Parts A and B.
Those cover your doctor visits and hospital care, things you'll also get in an all-in-one Medicare Advantage plan. But all-in-one Advantage card holders may get so much more.
I have only one card, and that card helps me with my vision costs, my dental costs, my pharmacy costs, my doctor costs.
Let's scroll a list of the potential benefits that can be covered with this single kind of card. And remember, in addition to all of this, you're still getting the Medicare, hospital, and medical benefits to which you're entitled. Oh, and are you sitting down? These plans may have a $0 monthly premium depending on where you live, no matter your health status or how much money you earn each year.
It is not trickery at all when you hear $0. I'm proof positive.
I love the $0 plans. That fits my pocketbook really well.
Compared to original Medicare recipients, people with one of these all-in-one Medicare plans had 23% fewer hospital stays and 33% fewer emergency room visits, while also receiving more physician office tests and services.
I love my Medicare Advantage plan. I wouldn't get away from it for anything in the world. It's perfect for me.
I have been able to go out and live a healthy lifestyle, been able to do all the things that I need health-wise, and because I'm able to do that, I feel good about myself, and it has saved me so much money.
One card, one company, one complete and convenient package of Medicare benefits to help you get well or stay well.
And for one low or no monthly plan premium. That's the kind of value you can't afford to ignore. So why not find out more right now? Here's how.
Call 800-525-7153 or visit thiscard800.com for free information about this incredible card with no obligation of any kind. This is free information that could give you more coverage for less money. Call 800-525-7153 or go online now to learn more.
Best Fiends. Collect JoJo and tons of other cute characters. Solve thousands of fun puzzles. Download Best Fiends for free today. That's friends without the R. Best Fiends.
With the money I've made on Poshmark, I've been able to pay for all our family's vacations.
I could pay for my wedding just on what I've made from Poshmark.
I've made over $10,000 and I was able to buy my new car.
Download the free Poshmark app now.
Welcome to Closing Arguments. I'm Seema Iyer in for Vinnie Politan, and don't you worry, because Vinnie will be back tomorrow night. Now, with me this evening is my think tank, Charles Middlestad, criminal defense investigator to the stars, Shania King and Michael Bixon, criminal defense attorneys and beloved members of Court TV Fan Club. Okay. So this case, we're still going to talk about Wisconsin versus McCandless. And one issue which we don't see a lot, Shania, in the courtroom is when lay witnesses get to give their opinions, right? Because what are lay witnesses supposed to be allowed to talk about?
Stuff they observed, common things, but they don't have the right to say expert things like whether or not a blood spatter was from a certain distance. It just doesn't happen.
Exactly. So the state has proffered 10 lay witnesses. Check this list out. These are a lot of names, and there is a variety of topics that these people think they can just parade into a courtroom and talk about, but we know they cannot. So this is what are you looking at?
Jason Mengel, a lay witness?
Well, he's not an expert.
No, but he's not independent. I mean, my definition of a lay witness is also sort of an independent witness. He's not. He's connected to the defendant in this case.
Oh, well, they all are. So, yeah. So, okay. So when I get, like, under the law, I guess what they're basically saying is lay witnesses versus experts. And that's exactly the danger. What kind of Shania was saying is that, hey, these people can't come in and give their expert opinions on whether it's her gender identity issues or her mental health. So the law specifically states, and this is the Wisconsin law, that lay witness opinion is allowed when it is based on witness perception, it's helpful to understanding witness testimony or determining a fact in issue, and it's not based on scientific, technical, or other specialized knowledge. So, Bixon, from what you know about the case so far, just generally speaking, what would you say that people can't come in and talk about?
Well, I mean, based on that law, that certainly broadens a lot of it. I mean, if you're going to allow them to testify as to their opinions on basically anything that they've seen or heard or somehow were involved with in this case, it's really going to open the door to, I mean, God, almost anything, really.
Like, for instance, okay, so let's show the list again. So the first witness on the list, Joe Shane Carlin, wants to come in and say, quote unquote, about Ezra is bat bleep crazy. Does that sound?
You were very careful about that.
Well, excuse me.
Around that one.
Wait, excuse me. Do you understand there's like a Court TV banned word list, and it literally says like Court TV parentheses Seema Iyer don't say these things on the television. So I'm very careful. So, but isn't that a legal conclusion to say someone's crazy?
Well, yeah.
Or an opinion?
Yeah, absolutely. Exactly, and it goes towards so many different issues that I would object to. I can't even get started. And I mean, really, I mean, you would have like this rolling list of objections, and I can't imagine that these people are going to be able to come in there and do that. And I understand that if they want to testify to specific things that they have seen or heard or witnessed, but when you talk about that, I mean,
okay.
Let me see your credentials. Come on.
And I think, and just so for the judge did like a provincial ruling? That may not be the right word. Provisional ruling, that's the right word. Provisional ruling that basically says, okay, you can talk about facts and observations, but not get into opinion. But I think the judge also said he'll take it witness by witness. For instance, another witness on the list, Court Fox, he is proposed to say that she came from an ultra-conservative Christian past. Is that something, Shania, that you think would be relevant in this case?
I think it's relevant, but why do we need that to come from that witness? Can't we just put it on through the presentation of the evidence? I don't think that witness is relevant.
Well, maybe. I mean, this is what the state thinks it's relevant, at least to the narrative. But it certainly doesn't sound objectionable, right, Charles? I mean, it's just a fact. Yeah. Right. So it's not that. I don't think it's very.
Even then, I think you can easily object to it. I mean, how does he know that, right?
Well, maybe they go to the same church.
Well, yeah, but even then, it's a very subjective thing. You know, to look at something and
I'm sorry. If he's been in her house and sees how her parents behave, like that kind of atmosphere, and it could end up helping her.
I think it could. And again, not just that, but we also forget the fact that, look, the defense has an opportunity to stand up and cross them on this issue. So it's not going to go totally unchallenged. And even if you lose the objection to it, you can still cross them to death on these issues. And I think there's a lot of cross of how do you know that? How can you actually testify to that?
Yes.
So you can, there are ways to turn it back around, but you don't generally want to have to go down that road as a defense attorney.
But it also opens up, it's fair game for the defense, too, to get these witnesses to opine on things, right?
Sure.
I mean, they could benefit from it as well.
Oh, of course. But they should still stay away from.
Once you get it out there and the jury hears something you don't want them to hear, it's kind of hard to get that back. So I would agree you can cross them, but I don't want certain things to get out in the beginning.
Well, I'm telling you, I mean, they have gone, I mean, there's just like motion after reply after response back and forth because they have been fighting this because it's 10 witnesses, that's a lot of people. And like, for instance, Mr. Fox wants to say that she had issues with depression. No, that's out. Sorry, Mr. Fox.
Unless she has told him that she had issues with depression or, I mean,
no,
again.
But it can't be depression. You have to say, I feel depressed. Because depressed is like a feeling, but depression is a diagnosis.
I agree.
But, okay,
maybe
now
you went and picked up her meds one day.
Oh, that would be good.
Right?
How convenient.
After reading the label.
But then, yeah, so he would have to say, like, oh, I picked up this medication, because there was another witness who wanted to say that she was bipolar, which will not be allowed in. But, for instance, so several witnesses want to say, or at least proffered to say, that she was transgender. Now, again, we are going forward with this trial, calling her she. That's what all the court papers say. That is, I believe, what the defendant is comfortable with. So should that be objected to? Is that relevant that some people have known her to be transgender. Do we want that in as the defense? The prosecution may want it in.
Is it a relevant fact? I mean, and that's what I have to know. Does it some way relate to this case, to the murder? And if it doesn't, it's not relevant. It has nothing to do with this.
I think it may actually benefit the defense because gender orientation and sexual orientation are two different things, and there's a lot of sexual promiscuity in this case that I think the jury could have a problem with, and you'd almost want them to sort of be confused about the two.
Oh yeah, that's good.
You know?
That is good. For defense, confusion is king. Okay, so now this other witness, Erin Hansen, wants to say the defendant is trying to get out of something, and that seemed like the only way for her to do it. This seems like Objection City.
100%.
Speculative.
Yeah, I can't
no
even.
foundation.
Look at Michael Bixon.
My hair would be falling out.
He's got a problem with something.
Yeah, right? I mean, it's insane.
Wait, actually, so and the motion says is that there are under the law that activities that relate to consciousness of guilt can come into evidence. So what do you say about that?
Are you kidding me?
I figured out what they're trying to do. They're trying to get out of paying a whole bunch of expert witnesses, so they're just gonna put a whole bunch of lay witnesses on the stand. I just figured out
a really
the trick.
good point. I mean, there's another witness who wants to say, Alexis Kexel wants to say that the defendant had a multiple personality disorder. Like, this is a free-for-all.
There's no way that these are not. I mean, if she's convicted, and you know that these are going to play a serious role in that conviction, that these aren't going to become significant appellate issues. And as a judge, I wouldn't want this to come in because it just muddies the waters. And you know better than that. I mean, these people, how can they actually make any type of testimony to this? And this is 100% expert testimony that has nothing, there's no reason to come out of their mouths.
When are we going to break? I'm going to cry.
I could see like these witnesses being groomed by the state and them saying like, would you be comfortable saying, blah, blah, blah. I'm like, yeah, I could. Yeah, I would actually, because I think it's true. But like suggesting.
Let me show you a copy of the DSM-4.
Yeah,
Why don't you take a look at some of these definitions here?
Is this consistent with your observations?
Foaming of the mouth.
Yeah.
But is this
In your
kind of like a fun
expert
game
medical
we're playing?
opinion,
Yeah.
I mean, I'm sorry, it would.
Well, okay. So, and these, I got to give you a few more. So, Matt Schreiber wants to say the defendant was emotionally unstable. Again, conclusory, right? You want to see. I want someone to say, I saw her do A, B, and C, right? Or heard her say these things. She did not take responsibility for anything she did. Conclusory city. The defendant's version of reality was warped. What is that? Is that even a thing?
I just don't even know. There's so much.
Can you believe that's an emotion?
They might as well prepare the appellate case now. We might
Yeah.
as well.
Seriously. I mean, do you really want this case floating back and forth that much? Because it's going to. I mean, that kind of testimony is so inflammatory, objectionable.
If this was your case, I mean, and I'm being completely serious, there are 10 lay witnesses on this list. How long does it take a defense team to prepare? Because you are having to investigate every single one of these people. I mean, this to me sounds like it would take years to prepare.
It's burdensome, for sure.
And this case
it's
is only a year.
burdensome, the way they're approaching it.
This is only a year and a half old, this case.
I forgot, is it an appointed case?
So, you know what? I don't know the answer to that. I don't know if the lawyers are private in this case. I don't know. I don't know that. But I will find that out. But, either way, I mean,
But the state generally doesn't offer those sorts of funds to indigent defendants.
Right.
Sufficient to be able to, listen, as hard as public defenders work, and they work extremely hard in defending their clients, their chief complaint is they don't have the resources to properly investigate cases, to pull in the right experts, whether it be jury consultants or medical experts or forensics experts or whatever. So, to your point about trying to prep for a case like this with this many lay witnesses, if it was in fact an appointed case, I just don't even see how you could mount that sort of defense.
I just have to push back on that only because from where I practiced in New York, I was never denied an expert, and I primarily, like 90% was court-appointed indigent defense. I'm very proud of it too, and I never have had a judge deny me an expert or time to prepare or investigators.
Really?
Yeah, and my investigators, would always ask that they get more money because if they're, I had investigators like you working on
I think you were
Sundays
very
and
fortunate,
weekends.
to be honest with you.
Yeah,
I don't think that's universal.
Yeah, no, I agree. But I just think that sometimes just people in this country don't know that, every state, every county is different. And that some of us are more fortunate in representing indigent folks. And it is hard for other lawyers. I completely agree with that. But this team, they're both award-winning defense attorneys. The lead attorney, Aaron Nelson, it says that he was honored for his work with indigent folks. However, I don't know. He could be a private lawyer, but perhaps he did pro bono work. But
no, not speaking of the quality of
of course.
counsel, just the resources.
Right, exactly, right. And that's a legitimate problem, right? Because you'd want to investigate every single one of these people on the witness list. And so you agree that you do, in a way, have to be put on notice as defense attorneys about what each of these people are going to say.
You'd like to be. But again, in some states, you don't know. You might look at the police report and you might see what they say, or they just might be listed on a witness list. And then, like in Georgia, we don't have depositions before trial. So sometimes you really have to go out on your own and
most
contact these people.
It's your responsibility to go try to talk to them.
Exactly.
Exactly.
So, but if you don't, you just generally won't know what they're going to say until you actually reach out to them and contact them and talk to them yourself.
Right, okay. So think tank, next up, we are going to discuss why the victim's character may be put on trial in this case. That's next.
Attention cancer victims who use the weed killer Roundup. A federal jury unanimously found that Monsanto's popular weed killer Roundup was a substantial factor in causing cancer. You may be entitled to substantial compensation. If you or someone you love used Roundup and were diagnosed with cancer, call the number on your screen now. Don't wait. There may be time deadlines to file a claim.
Call 800-549-6270. That's 800-549-6270.
Hi, my name is Sam Davis, and I'm going to tell you about exciting plans available to anyone with Medicare. Many plans provide broad coverage and still may save you money on monthly premiums and prescription drugs. With Original Medicare, you're covered for hospital stays and doctor office visits, but you have to meet a deductible for each, and then you're still responsible for 20% of the cost. Next, let's look at a Medicare supplement plan. As you can see, they cover the same things as Original Medicare, and they also cover your Medicare deductibles and coinsurance, but they often have higher monthly premiums and no prescription drug coverage. Now, let's take a look at Humana's Medicare Advantage plans. With a Humana Medicare plan, hospital stays, doctor office visits, and Medicare deductibles are covered. And of course, most Humana Medicare Advantage plans include prescription drug coverage. In fact, in 2018, Humana Medicare Advantage prescription drug plan members saved an estimated $7,400 on average on their prescription costs. Most Humana Medicare Advantage plans help you stay active and keep fit by including a Silver Sneakers fitness program at no extra cost. And you may be able to save on dental and vision expenses because coverage is now included with most Humana Medicare Advantage plans. You get all this coverage for as low as a $0 monthly plan premium in many areas. And your doctor and hospital may already be a part of Humana's large network. If you want the facts, call right now for the free decision guide from Humana. There is no obligation, so call the number on your screen right now to see if your doctor is in our network, to find out if you could save on your prescriptions, and to get our free decision guide. Licensed Humana sales agents are standing by, so call now.
Non-attorney spokesperson. This is a paid advertisement for legal services sponsored by Nightline Legal. Cases assigned on a random basis to participating law firms. See disclaimer for law firms.
Attention cancer victims who use the weed killer Roundup. A federal jury unanimously found that Monsanto's popular weed killer Roundup was a substantial factor in causing cancer. You may be entitled to financial compensation. If you or a loved one used Roundup weed killer and were diagnosed with non-Hodgkin's lymphoma, call the number on your screen now. The World Health Organization has designated glyphosate, the main ingredient in Roundup weed killer, a probable human carcinogen. Thousands of agricultural workers may have been exposed to serious health risks by using this product. You may be owed significant compensation from the manufacturer. Call now to find out if you qualify. If you or someone you loved used Roundup and were diagnosed with cancer, call the number on your screen now. Don't wait, there are time deadlines to file a claim.
1-800-568-4852.
Welcome back to Closing Arguments. The think tank is still with me. We are going to talk about why the victim's character may be put on trial in this case. Does it sound like, off the bat, this is at all appropriate? Young man, 25 years old, brutally killed, and now he may be the one on trial. Shania.
I think it's relevant. We need to figure out all aspects of the case. We need to figure out not only the defendant's motive, but why they got there in the first place. How did we get there? And you can't tell a story from one small perspective. You need the whole entire story.
Absolutely, and that's kind of the rule of completeness, right? Like that is part of what the legal fabric is made of, is that
Absolutely.
The jury should know everything.
The whole truth and nothing but the truth. And how do you judge something with only knowing half of it, right? I mean, they absolutely should get that in there. I think it's not just relevant, I think it's crucial.
Well, the defense has a list of actual physical evidence tied to the victim they would like to bring out, and we're going to show you some of that. One is Woodward's leather-covered journal entitled Extra Scriber, Woodward's leather-covered ledger book entitled I Met a Man Walking Through a Briar Patch. He was looking for the rose promised by the thorns. It's a long title. Woodward's orange 3-ring binder entitled Personal Notes, Research Ideas, and the Quest to Understand. Another journal entitled Dream Tree, Simple and Elegant. A personal copy of the book Corpus, a personal copy of another book, Fear and Trembling, and that's the physical evidence tied to him. So far, I think that physical evidence is so much more powerful than her getting on the stand just talking about him, right, Charles?
Can be. I mean, sometimes, testimonial evidence is, particularly if the defendant were to take the stand, right, the jury would be completely fixated on whether they believe her or not, and almost all other evidence would be ignored at that point. But absent that sort of testimonial evidence, the physical evidence has tremendous weight in a case like this.
Well, now in this case, and they'll probably talk about this a lot during the trial. They call it a Mcmorris Motion, and you know how everybody in the country knows what Miranda is because these Supreme Court cases, they're so commonplace in our vernacular. But as you guys know, for wherever you practice, every state has a different kind of like, hey, Shania, did you file that Mcmorris motion today? We know what we're talking about because we're in the same building. So in this case, the Mcmorris, this is the idea of the victim's character coming into evidence. And the law in Wisconsin specifically allows for this exact circumstance. So the Wisconsin Supreme Court has said in Mcmorris, the past conduct of a person markedly affects what others may reasonably expect from him in the future. When the individual maintains self-defense, she should be permitted to show she knew of specific prior instances of violence on the part of the victim.
If those journals have anything to do with any of that, then absolutely they should get in. I mean, in his own words, all day long. All day long.
But there has to be the connection made that she knew. So that's the first hurdle, right, Shania? That she, in fact, knew of his musings, of his ideations about cannibalism and BDSM and those type of perhaps arguably violent behaviors.
Absolutely. She can't benefit off of hindsight. She had to know before she committed the murder, allegedly, that these were his ideologies, this is what he believed, and this is what led them to be defendant and victim in this case.
Now, according to one of the defense motions, the defense does write that Woodward shared the contents of his journals with McCandless over a period of time, and by the date of the incident, March 22nd, 2018, she had complete knowledge of his writings. How powerful is that?
Well, that means she's got to testify, right?
That's what I'm thinking.
She has to testify.
Well, okay, so yeah, talk about what we were talking about during the break.
In regards, because we talked about a lot.
Okay. Well, we didn't talk about like what you did this weekend, Bixon. We talked about the self-defense issue, and so you were saying,
as far as her taking the stand.
Yeah.
So I think here's the risk and the reward. Okay, and I think the reward is getting that jury instruction. That's the big what you want to gamble it on. Now, if there's any way whatsoever to get that jury instruction in without her testifying, go for it. And even then, I honestly think if you can't get that jury instruction in without her testifying, she still does.
Right. Well,
how do you get over that first hurdle without her testifying?
Yeah, no, I completely agree with you. Because, okay, so the jury instruction thing, I just want to, and tell me, Shania, if you've ever been in the circumstance, but what's happened to me is I wanted to argue self-defense. I didn't want my client to testify, and what I think on one case, I got the instruction without him testifying because he had like a police interrogation video. So great. He didn't have to testify, had the video, got the instruction. In another circumstance, he didn't testify. There was like a report or something that established self-defense, wasn't enough to get the instruction, but I was able to argue it in front of the jury. So there is another option. But right now,
so you're thinking maybe in her interrogation video, she talks about the fact that she shared that?
No, I don't think there's an interrogation video. I think it's just that report. I don't know if there's a video. All I know is she was interviewed by doctors at the Mayo Clinic. Part of that interview is part of the criminal complaint. She was interviewed by police officers on 2 occasions.
Okay, but in the interview, you're thinking maybe she mentions the fact that he shared.
But she has to. I mean, that's my point, because I think if they want to get in this physical evidence of the victim's character, doesn't she have to testify? Doesn't there have to be something foundational, Shania?
But I think it was smart. You just hit the nail on the head earlier. You said that you could possibly just argue it in your closing argument, and at that point, I would ask for a lesser included, basically saying, don't find her guilty of this, but find her guilty of that if you're going to find her guilty of anything. I think that's a beautiful way to compromise if you don't want to give the self-defense instruction.
Would you? Okay, so if you had to choose between the defendant testifying, getting the instruction, the defendant not testifying, but you get to argue self-defense.
I wouldn't have my client testify.
Yeah, because if you get to argue self-defense, I mean, do these jurors read the instructions anyway?
No, I mean, like, they hear the jury instruction, but they're going to hear you even more than the instruction. Yeah. In your closing, I think that's going to be the most powerful thing for your entire case. And I think the journals and all the entries that he's put in there, I think that helps you get to, hopefully, that jury instruction, along with, I mean, already there's a police report out there of her making that report of self-defense already. So I think that in conjunction with the journals, you might get to that jury instruction, hopefully.
Yes. And also, I just want to point out that the defense is including in their application that Mengel, the boyfriend at the time, that was the boyfriend at the time. So there was like the 3 boyfriends.
Confusing. You need the chart.
We need a chart of love. We need a chart of love. The chart of love. So Mengel is supposed to testify, and specifically, he would say the following at trial: that McCandless used to date Woodworth. Woodworth made threats to kill himself if McCandless didn't leave Mengel and come back to him. And Mengel had been with Woodworth when Woodworth had slit his wrist.
Now, as you're talking about that, I recall reading something about some of the digital evidence in this case, also in the form of text messaging. And I'm wondering if some of those text message exchanges where he's making that threat appear within the evidence, which would overcome that first hurdle.
Right. Oh, right. That's
good.
So
then there's no testimony needed. That's the hurdle.
I really don't want you guys to get what you want. I want her to testify, okay? So just put a pause on that. All right, let's head out now to Court TV legal correspondent Shanley Painter for an update on what to expect tomorrow in this case.
Tomorrow, day 1 in the case of Wisconsin versus Ezra McCandless. It'll begin 9:30 Eastern with opening statements, the all-important opening statements that the prosecution will paint a picture of what happened back in March of 2018. Of course, the defense will paint a different picture. She's charged with first-degree murder for stabbing to death her ex-lover. Of course, she says it was a sexual assault. She was defending her life at the time that it happened. Those are the themes that we will hear in the morning, and it's going to be extended over an hour each for opening statements. and then the state will begin to call its first witnesses in its case in chief. We can expect to hear from family members of the victim, 24-year-old Alex Woodworth, and his mother, his grandmother are expected to take the stand to tell this jury more about who he was as a person. And then the prosecution even plans to call the medical examiner tomorrow to describe the injuries, cause, and manner of death, 16 stab wounds. So it'll be a long day here in Wisconsin. We'll send it back to you.
Thank you so much, Chanley. Okay, next up, we are going to give you an update in the Hammer Hitman murder trial. Today, Judge Kyle getting riled up. That's next.
This is Court TV.
The network designed for true crime.
Not justice! No peace!
He had to shoot to defend himself.
Something was not right here.
What does the jury need to find the truth?
It's a very stressful situation.
We are bringing you gavel-to-gavel coverage.
You'll see and hear all the evidence.
We heard 911 calls.
I need help now! The truth will always prevail.
This is Court TV.
Your front row seat to justice.
Your paycheck. Your family depends on it. But if something happened to you, you need life insurance. And chances are SelectQuote can get it for you for under $1 a day.
SelectQuote found Alec, 38, a $500,000 policy for under $23 a month. SelectQuote found Kenesha, 37, a $750,000 policy for under $23 a month.
SelectQuote's secret? They impartially shop a select group of highly rated companies like these for your best rates. Give your family the security it needs at a price you can afford.
Since 1985, SelectQuote has saved over 1 million families millions of dollars on life insurance. Call now. 800-280-0164 or go to SelectQuote.com. Discover what over 1 million families know. We shop, you save.
If you have Medicare, listen up. The Medicare enrollment deadline is only weeks away.
With so many changes, do you know if your plan is still the right fit? Having the wrong plan may cost you thousands of dollars out of pocket.
And that's why I love Health Markets, your insurance marketplace.
With their new Fit Score, they compare thousands of plans from national insurance companies to find the right Medicare plan that fits you. Call or visit Health Markets to find your Fit Score today. In minutes, you can find out if your current plan is the right fit, or if there's another one that can get you extra coverage or help save you money. Best of all, their service is completely free. Does your plan have $0 copays, $0 deductibles, and $0 premiums? If not, maybe it's not the right fit. Does it include dental and vision coverage? Well, if not, maybe it's not the right fit. How about hearing aids, glasses, and gym memberships at no additional cost? Maybe there's a better fit for you. Call Health Markets now or visit healthmarkets.com for your free Fit Score. We can instantly compare thousands of Medicare plans with all of these benefits and more, including plans that may let you keep your doctor and save money. With the annual Medicare enrollment deadline coming, don't waste another minute not knowing if you have the right Medicare fit. For this free service, go to healthmarkets.com or call right now.
Having helped enroll people in millions of policies with an A-plus customer satisfaction rating, you can trust Health Markets.
Don't assume that your plan is still the right fit. The Health Markets Fit Score makes it easy to find the right Medicare plan for you.
Health Markets doesn't just work for one insurance company. They work to help you, and they do it all for free.
Your insurance marketplace, Health Markets.
There may be Medicare benefits and savings you're missing out on. Only Health Markets has the free Fit Score. Call 800-290-6422 before the deadline. That's 800-290-6422.
In balmy Bonita Springs, Florida, on June 28, 2015, a doctor, Teresa Sievers, was just arriving back home from vacation alone. She planned to go back to work at her busy private practice, but she never made it to the office.
She's dead on the floor, and there's a hammer at the side.
The next morning, police discovered her body and a bloody scene in her kitchen. The 46-year-old wife and mother was brutally beaten to death in an ambush attack. all while her husband, Mark Sievers, and their 2 daughters were states away in Connecticut.
This is was a very safe neighborhood.
Her horrifying death shook the community to its core. Questions swirled as her family searched for answers.
It's a very emotional time for everybody. So we just ask, that everybody just keeps everyone in these circumstances right now in their prayers.
With no suspects and few leads, police interviewed everyone, including Teresa's mother.
We both were up in the yard screaming, crying. I guess she can keep me alive now from heaven.
More investigation revealed Teresa and Mark's marriage of 12 years had many layers. Teresa's obituary describes Mark as her loving husband. Friends and family said the couple had typical arguments, often stemming from their shared work. Mark managed his wife's medical office and was a stay-at-home dad. Teresa's practice specialized in anti-aging and holistic care and was inspired by Eastern medicine. But Mark and Teresa's work relationship wasn't the only thing unconventional. Cell phone records and letters recovered by police detailed Mark and Teresa's open marriage, other sexual partners, and a fantasy Teresa had involving Mark's friend, Curtis Wainwright. 11 days after Teresa's brutal murder, a tip from an informant took investigators to Missouri.
I seen like 20 SWAT guys or so, a whole bunch of jackets and flag jackets and a whole lot of rifles.
Their investigation led them to a suspect, Jimmy Ray Rogers.
Asked us if we see anything suspicious to give him a call.
Rogers lived in this mobile home park with his girlfriend, Taylor Shoemaker. She would tell investigators Rogers made an unexplained trip to Florida.
I asked him what he went down there for, and he said to make money. And then asked him how does he make money, and it was murdering Mark's wife. I said, did you shoot her? And he said, no. And I said, then how'd you kill her? And he made a stupid little chuckle that he does, and then said, with a
Neighbors pointed to another connection. Rogers was good friends with Curtis Wainwright.
He used to go over to Jim's all the time.
Police arrested and charged Rogers and Wright with Teresa's murder. But for the Lee County Sheriff's Office, the case was not closed. Mark Sievers fell under what Sheriff Mike Scott called an envelope of suspicion. Months would pass, and Mark remained a free man, fighting to keep custody of his 2 daughters.
Is this out of control? Yeah, we would say it is absolutely out of control. We've got an ongoing criminal investigation which can and will very likely result in the arrest of additional suspects.
Mr. Sievers, should you be incarcerated, who do you want to have custody of your children?
Then on February 6, 2016, 7 months after Teresa's death, deputies would make their 3rd and final arrest.
I think a lot of people have been waiting for this day.
Mark Sievers was indicted on charges of first-degree murder for orchestrating the deadly scene.
Wainwright, Jimmy Rogers, and Mark Sievers are locked up where they belong.
Life insurance policies worth nearly $5 million only added to the prosecution's case about a sinister plot. Police allege Mark conspired with his friend Wright as early as April of 2015. Then in June of 2015, Wright solicited Rogers to travel with him from Cadet, Missouri to Bonita Springs, Florida. There, authorities say the 2 men caused Teresa's death by blunt force trauma.
Anybody who has a heart is feeling very sad for those children right now.
Rogers and Mark Sievers pleaded not guilty, but Wright turned state's evidence and took a deal in 2016 just before Sievers' arrest. Wright is expected to testify against his 2 co-defendants who both face the death penalty if convicted for the murder of a woman who spent her life helping others heal.
And that is the Hammer Hitman murder trial in a nutshell. Now today, it wasn't just witnesses on the stand. No siree, folks. There were fireworks after a disagreement over the deposition of a potential FBI agent. This is so good. Check it out.
So no, my questioning in deposition did not specifically include what wasn't involved, what wasn't received, because I didn't receive it.
Well,
I understand what you're saying, but this electronic data has been a problem throughout this entire case. you know, with receiving hard drives and disks and not knowing what's on it or not being able to access it.
The problem is that I can't force federal agents to come to court. You need permission from the federal government to even depose them, and they can say no. I don't have the authority to force them to send anything. So the appropriate mechanism was to do what we did today and to sit her down and ask her, I've got this disc right here, and this is what's on it, is all of these things on it. And then she can look at it and say, yes, it is, or no, it's not, which wasn't done until right now. And she hasn't even looked at the disc. She says it's all on there, and I believe her.
I don't disbelieve her. I don't disbelieve that possibly the state has it. What I'm saying is I didn't get it.
The state,
had so much.
I'm going to stop. The state turned it over. She said it's in a PDF file. The state said they gave it to you in a PDF file. You have it.
I have what I could open. I can't find.
You can step down, ma'am.
Nor could Dr. Leiter, who I've consulted with. So.
Well, those are great. Those are great questions for him when he gets on the stand too, to say that they don't exist, and then their witness will say they do, and then the jury will weigh it and figure it out if we get to that point.
Going back to here, I'm just saying it should not be held against Mr. Rogers. I've been expressing this to the court for quite some time. I understand you have no control over.
I'm going to stop you right there. You put me into a conundrum where you guys haven't asked her if she had it. You guys didn't show her a disc, and you decided not to depose her because you said you didn't have it. And then I am in the position I can't produce these things, so we would just wait infinitum to have trial if we were just waiting for something to come that the FBI has said they've already given you. And the proper mechanism is to do what we just did and to ask her if you guys want to show her the disc and she can show you where these things are. And if the state has said they've turned it over, I don't know what you would expect me to do, because what you're basically saying is we would never go to trial.
No, I expected a continuance that I asked for and I laid a record for to give me an additional couple of weeks to be prepared on this. That's what I would have expected. However, I defer to the court. This is your court. I'm here. I'm doing what I can. It's their job to get it to me.
Well, it's not
hers even.
It's not my court. It belongs to the people of Southwest Florida. I'm just occupying a seat for the given time. And the state says they've turned it over, and that is their duty and obligation, and they say they've done it. If you guys want more time to go show them the disc and make sure that it's really on there, I don't have a problem with that. We can do that right now.
And Your Honor, may I put on the record that those discs are, because they were PDFs uploaded to provide, are pages 84282 through, pardon me for sitting down, Your Honor, I need to move the computer down, to 89079, numbered sequentially, all provided.
I think the underlying issue, too, has been the absolute reluctance of both parties to speak, too. Even on the eve of trial, you guys hadn't even talked about a possible resolution until I told you guys to sit down and do it. I mean, do you want more time to go see and walk through these with counsel, with your witness? I'll give it to you, and we can take a break.
I'm not sure I understand what counsel is saying, because
She's saying she didn't get it, and she's saying it's not in there, and she doesn't see it, so maybe your witness can point it out.
I don't see it to the extent that they say it's there. And I have specifically weeks ago pointed this out to Ms. Ross. Exactly. I highlighted the areas that I don't have, which I just read to the court.
Your Honor, the state cannot produce what the FBI does not give. The state produced everything sent by the FBI.
I'm going to stop you.
Those are the numbers.
I'm going to stop you, and it's a clear issue one way or the other. Do you guys want to recess for the rest of the day, and you can sit down and she can point those things out since she says they're in there, or do you guys want to continue with a witness? And your previous objections are noted for the record. I'm proceeding to trial and renewed at this time, and I note them for the record. State.
Your Honor, the state has no problem taking the time, if the court recesses, to sit here with the computer opened and show Ms. Fitzgeorge each of these discs.
So you have no preference. Okay. Defense.
Do I then get time to consult with my expert?
You've had this information according to them, but to make sure that it's really there, if you want time to talk to her now, that's the question. That's what I'm asking you. I'm not talking about anything after that right now.
But you're presuming that they're telling the truth and I'm not.
I had a witness up here under oath who's the one who sent it. And I'm giving you another opportunity to go talk to her so she can point those out. I'm not saying anyone's lying. And to put that on the record, I think is unfair to say that that's what I'm doing, because that is not what I'm doing. Do you want more time to talk to her and she can point out the things you say are missing in the PDF that has been disclosed or not? Right now, I'll give it to you. Okay, excellent. Bring the jurors out.
I am here for Judge Kyle. I am on board with this guy. Okay. You guys were just like chit-chattering the whole time we were watching that, so I want to get your thoughts. Now, Charles, you go first because you said this wasn't rocket science.
It's not. I mean, the state has a certificate of service for all discovery that's been produced to the defense. So they should be able to produce that and say, look, here's the proof. We gave it to you. Now, what it sounds to me like there's tremendous acrimony between the prosecution and the defense, and they don't talk, and that's probably what's responsible for this, because the defense is basically saying, well, we got some stuff, but we weren't able to open it and we couldn't see it. Well,
no, but that's a problem with certificate of service, right? Because you may have the certificate.
Drive. It'll just say we gave you this drive.
Right. So they have to look through it.
Yeah, but don't wait until the eve of trial to say,
during trial.
Or during trial to say I couldn't open it. I mean, get with the agent. Call the agent. I've called agents before and said, I can't open something. Can you help me? Can I come to your office and look at it? Can I do whatever?
Exactly, because it just, law enforcement, prosecutors, we're all part of the same process, and people have the professional respect to do that. Absolutely. Okay, so Shania's comment was something about Brady material.
Yes, if I'm the defendant, I'm terrified right now because my lawyer can't even access some of the discovery. Here, the Supreme Court, the Supremes I call them, came out with this famous case that says you have to give the defendant exculpatory material. If it goes to their innocence or their guilt, you have to give it to them because it's important in preparing for the defense's case.
But at this point, does it look like it was the defense's fault? Do you think they're disingenuous in their accusations?
I mean, look, I've gotten things before that were password locked or inaccessible because you need a specific program to open it or something like that. But you call the prosecutor, say, hey, look, I can't open it.
All the time.
And then one way or another, you get it fixed before trial.
I would go to their office all the time.
Acrimony. You could tell they're not talking.
I understand that. It looks like she might have found some pretrial motions. It looks like she asked for a continuance. Sure. I don't know if she actually enumerated what was going on in terms of that and listed this as a specific thing that she couldn't access or something like that. But I think it's something that she should have put on the record from the beginning that, look, if I can't access this, it shouldn't come in.
Right. Okay. Now, what do we think about the judge's reaction? How did the judge handle this?
He seemed a little intimidated by the fact it was a federal agent there and that he needed to handle her with, some white kid gloves or something, because...
Well, maybe because, as he was explaining, he doesn't have jurisdiction over it.
No jurisdiction, but he is responsible for this case and ensuring that the defense has access to the discovery, right? He has jurisdiction over the prosecution and what they do and can order them to produce certain things. So while he may not have jurisdiction over a federal agent, he can certainly control what the prosecution's obligations are.
Wow, yeah, let's see what kind of mood he's in tomorrow. Okay, we are going to take a break and we're going to continue talking about the Hammer Hitman murder trial on the other side.
This is the kind of card that has America talking. With it, people with Medicare are getting all-in-one coverage for their doctor visits, hospital care, prescription drugs, and more. This kind of insurance, called Medicare Part C, may also cover dental care, eyeglasses, hearing aids, fitness programs, vitamins, even healthy meals and rides to the doctor. With this kind of coverage, you do not need a Medicare supplement insurance plan. You will access your benefits through your Medicare Part C plan for one low and oftentimes $0 monthly plan premium. You deserve to get the most from your Medicare benefits. Call now for free information that may help you get more coverage for less money. There is no obligation to enroll. Whether for yourself or someone you love, call the number on the screen now. Call now.
We got one of those new purple mattresses, and it is amazing. You have to try it.
You didn't need to...
Shh. Just lie down.
Oh, this doesn't feel like memory foam. No. This feels amazing.
Right?
What is it?
Actually, it's called Purple, and it's nothing like memory foam. It's a totally unique gel grid technology, meticulously designed to cradle and support the human body. It sleeps cool, it's motion isolating, and honestly, I love it more than 2 of my 3 children.
Cool.
We loved our Purple so much, we got one for the guest bedroom. That way, when my in-laws come, they can stay in my bed and I can start.
Okay, feel that? Adapts instantly.
Honey!
Oh, hey, honey. Yeah, so just showing the guys the new Purple mattress.
For 48 hours only, save up to $400 on a Purple mattress and sleep bundles at purple.com/TV.
When you're looking for answers, it's good to have help, because the right information at the right time may make all the difference. At Humana, we know that's especially true when you're looking for a Medicare supplement insurance plan. That's why we're offering 7 things every Medicare supplement should have. It's yours free, just for calling the number on your screen. And when you call, a knowledgeable licensed agent producer can answer any questions you have and help you choose the plan that's right for you. The call is free, and there's no obligation. You see, Medicare covers only about 80% of your Part B medical expenses. The rest is up to you. That's why so many people purchase Medicare supplement insurance plans like those offered by Humana. They're designed to help you save money and pay some of the costs Medicare doesn't. Depending on the Medicare supplement plan you select, you could have no deductibles or copayments for doctor visits, hospital stays, emergency care, and more. You can keep the doctors you have now, ones you know and trust, with no referrals needed. Plus, you can get medical care anywhere in the country, even when you're traveling. With Humana, you get a competitive monthly premium and personalized service from a healthcare partner working to make healthcare simpler and easier for you. You can choose from a wide range of standardized plans. Each one is designed to work seamlessly with Medicare and help save you money. So how do you find the plan that's right for you? One that fits your needs and your budget. Call Humana now at the number on your screen for this free guide. It's just one of the ways that Humana is making healthcare simpler. And when you call, a knowledgeable licensed agent producer can answer any questions you have and help you choose the plan that's right for you. The call is free, and there's no obligation. You know Medicare won't cover all your medical costs, so call now and see why a Medicare supplement plan from a company like Humana just might be the answer.
I thought before the jury came back in, we could finish addressing.
Yes, ma'am.
I just need, then if we can make 25, just a court exhibit so that it's clear that the state set up the authentication and relevance of 25A.
Sure, we'll show 25 as a court exhibit and we'll take it into evidence.
Thank you.
I'm going to ask both sides to go through anything you're going to try to move into evidence so we can take care of any issues like this in advance. This should not be a stalling issue, what we're doing right now. You guys haven't asked her if she had it. You guys didn't show her a disc and you decided not to depose her because you said you didn't have it. And then I am in the position, I can't produce these things, so we would just wait infinitum to have trial. If we were just waiting for something to come that the FBI has said they've already given you. And the proper mechanism is to do what we just did and to ask her if you guys want to show her the disc and she can show you where these things are. And if the state has said they've turned it over, I don't know what you would expect me to do, because what you're basically saying is we would never go to trial.
I'm doing what I can. It's their job to get it to me.
Well, it's not my court. It belongs to the people of Southwest Florida. I'm just occupying a seat for the given time. You've had this information according to them, but to make sure that it's really there, if you want time to talk to her now, that's the question. That's what I'm asking you. I'm not talking about anything after that right now.
You're assuming that they're telling the truth and I'm not.
I had a witness up here under oath who's the one who sent it. And I'm giving you another opportunity to go talk to her so she can point those out. I'm not saying anyone's lying. And to put that on the record, I think is unfair to say that that's what I'm doing, because that is not what I'm doing.
Oh my God, I love this. This is so good. Look at the judge.
But I don't see any tears.
Wrong trial. Wrong trial. Okay. So I want to get back to Bixon, because Bixon, you were saying that you thought this judge was being indulgent.
I feel like I would have been thrown in contempt halfway through this. I mean, I'm just shocked that he even indulged them really that much.
Well, how should he have handled this?
Well, because I mean, look, I haven't seen all the pretrial motions, so it's very reasonable to say that maybe the defense brought this up, that they weren't able to open this disc, and that's why they asked for the continuance before. But maybe they didn't. And I think depending on which scenario it is, it's really on the defense to get that stuff before this started, and to bring it up in the midst of the trial, and to sound so accusatory, and to really berate the judge almost, and for him to go back and forth on the stand with it. I mean, I just feel like in most courtrooms that I've been in, if you would have sort of played it out like that, you would have been in cuffs in the back in contempt, and that would be it.
Do you think he handled this wrong?
I think this can go on infinitum.
Your whole life, why did you say that word? Okay, Charles has said that you thought he was being a little too, I'm going to clean it up, neutral?
Yeah, he's like Switzerland. It's his court. Yes, it's the people's court, but he's not Judge Judy. It's his court. He needs to control it. He needs to get to the bottom of who's responsible for a potential discovery violation. Or, hey, state, show me your certificate of service. Okay, here's the state certificate of service. I'm not taking their word for it.
Yeah.
They're saying they produced it to you. Now, what's the problem? You couldn't open it? Okay, so when did you realize you couldn't open it? And when did you bring it to the prosecution's attention that you couldn't open? What remedies did you take? And if they have everything documented, I've been involved in situations before we couldn't open something. I got with an agent. Maybe they were cooperative. Maybe they weren't. So guess what? That's when I come in. Defense attorney says, hey, listen, I even sent my investigator to go try to open this thing with the agent or with the deputy or whatever agency was the custodian of that information, right? And they either weren't cooperative or they couldn't open it, and we asked for a new disc. There was the faulty disc or whatever. Would you like to hear from my investigator? He'd be happy to testify. You know what I'm saying? I mean, you get to the bottom of it.
Okay, but Shania, don't you think that perhaps maybe the judge didn't want to do this in open court? Like, should he have called everybody into chambers or perhaps a sidebar to get more into what happened, get some answers?
If it was my case, I would want it behind closed doors, but for court TV, it's juicy. I love it.
It really was. I still love the judge, Switzerland and all. Okay, so now let's get a preview of what we can expect tomorrow from Court TV's crime and justice reporter, Julia Janae, in Fort Myers, Florida.